Professor Keating is graduated summa cum laude from Amherst College, earned an MA and PhD in political philosophy from Princeton University, and graduated magna cum laude from Harvard Law School. Professor Keating is an editor of Tort's Casebook and writes on torts, professional responsibility, and legal theory. He has published articles on the morality of reasonable risk imposition and the law of negligence. Professor Keating will be talking about irreparable injury and the incompleteness of tort. Your time, professors, you have 30 minutes.
Thank you.
Let
me try this. Let's see. I think I'll wander around slightly and peripatetic or something. Thank you very much for the introduction, for having me here. So this is a piece of a book I wrote, really carved out, and I'm interested in general, but I'm also interested in your thoughts on it. If you happen to solve a problem that I draw a complete dead end on at the moment, which is one of the fundamental things here is about asymmetries, and I'm starting to think about autonomous vehicles. And it's clear that people have asymmetric views about the amount of safety that they want from autonomous vehicles. And the classic question that always comes up is that rational or irrational? Anyway, let me talk about this. So this particular paper has, I think, two dominant themes. One is that tort law is intrinsically incomplete. And here I'm sort of, I think of myself as pushing back in some sense against two strands of thought that are very prominent in North America. One is corrective justice theory, and another is law and economics. And the argument that it's intrinsically incomplete begins from the idea that the default tort remedy is reparation for harm done. And the problem is that reparation is rarely fully adequate. Reparation, there's a certain sense, but I think this may not matter, that you might say, well, reparation is never adequate because you lose time and you can never get time back. I remember long ago having a conversation with an economist colleague of mine about what is the ultimate scarce thing. And then he said, I think it's time. And because of mortality. So true enough. So you consume time in any kind of litigation, and therefore you can never fully repair the effect of any wrong that needs to be undone. But that may be so true of everything that it's not what cuts ice here. The fundamental idea in terms of what cuts ice is there's certain kinds of damage. And think of it as damage that counts as tortious to fungible commercial property. So I use the dock in Vincent Lake Erie as my example here. And if you destroy the dock or damage the dock, you can either repair the dock and it's good as new, or if you destroy it completely, it's just commercial. Dollars cash out all the value that it has. And in that sense, reparation can do what it is that reparation claims to do in the standard rhetoric. I should say the standard rhetoric, interestingly, includes different formulations, but a standard formulation would be to put the plaintiff in as good a position they would have been as if this hadn't happened. Or an economist would put it back on an indifference curve where they were before this happened. And that's true with respect to commercial property. It's not true with respect to the stuff that we actually care about, which is physical injury. Physical harm, which does include property damage, but think of it as damage to persons. The more serious it is, the more irreparable it is. And this isn't to say that damages can't do a great deal for you, but what they do for you is really to enable you to build a new kind of life. So that even if you're thinking of property, but it's not property that's purely fungible, it's property invested with personality. So you're thinking of something like your own home. If your home burns to the ground, insurance money damages can do a lot for you. But what they'll do for you is to enable you to construct a new life, not to put you back on the narrative arc it would have been, but for the loss of your home. And that becomes truer and truer when we think of physical harm. For example, if something inflicts a severe disability on you, you won't be brought back if you lose both your legs to the condition that you were in before you lost your legs. You'll be put in a position where you can build a new life, which may enable you to overcome that impairment fully or not, but it won't be putting you back in the position that you're in. Well, the limiting case of this is death, and there's no putting anyone who's died back on the indifference curve they were in before they were dead. And this has always been recognized in tort law because tort has never recognized damages awarded to the victim of wrongful death for the value to the victim of the life that they have lost. And if you look at the history of wrongful death damages, there are no wrongful death damages at all in the 19th century. There's been massive statutory development since. In North America, it's two different statutes, a survival statute and a wrongful death statute. I talked briefly about what they are in the paper. The key point for our purposes here is it's very telling that they're statutory because tort reached the limits of its powers of repair when it confronted death and said, well, what are we going to do about that? And statutes come along and in various ways attempt to address it. But even statutory mechanisms which reach to the point of recovery for what the victim would have had if they survived the injury for a certain amount of time and hadn't died, period of time that they were alive, and they reached to the harm to other people, the relational harm that people suffer from wrongful death, those who were dependent financially or emotionally upon the killed person. But it doesn't reach, except in 2 or 3 jurisdictions, there's a kind of damage called loss of enjoyment of life damages. And the overwhelmingly majority view, like 47 states, is you have to actually be alive to be suffering loss of enjoyment of life damages. We don't have to award damages for that to someone who's died. And what that means is 2 ways of thinking about it. I think from the point of view of the basic theories of tort, tort can't repair the harm that we are most concerned to avoid, harm that's most severe to us. And that's a difficulty if you think of tort as a corrective justice system preoccupied with reparation. But if you think of it from an economic point of view, tort's a pricing mechanism. Tort is a kind of shadow market in which what you're trying to do with damage awards is to value the harm in such a way that it's registered properly by rational actors, so that rational actors will not injure and kill other people when it would be inefficient to do so because you would be creating, you wouldn't be maximizing value, really cashed out as wealth. But if you cannot, the system doesn't even attempt to price the worst harm that people can suffer, then the pricing mechanism is intrinsically incomplete. And so the other main theme of the chapter is there is a solution to this, and it's regulation. And that it's regulation and not, although these things I don't mean to say they don't do something, but there are 2 other places that the literature and I think actually the law goes. One is towards the expressive role of damages, which I'm not against. It's very important, but the expressive role of damages has limits. It doesn't even attempt to claim it can repair this harm. It does very interesting things, but doesn't really solve this. And the other is to think of punitive damages. And punitive damages can do something here, but punitive damages are really calibrated to a different problem, because the problem of punitive damages is really the question of whether tort law should respond differently to various kinds of egregious wrongdoing and what counts as egregious wrongdoing. It isn't the severity of the harm. It's the fundamental concern of punitive damages. It's quite possible to inflict devastating injury and even death with trivially careless conduct, given the kind of powers of the technology that we all have at our disposal, even in ordinary cars. So the problem there is that whatever can be done has to be done ex ante because it can't be done ex post. And the solutions that I think are in the legal system in the United States, I suspect there are other kinds of norms that I simply don't know in other legal systems. But the two I focus on are the safety and feasibility norms that you find in American federal statutory risk regulation. The safety norm is prominent in American federal environmental regulation. And it essentially says that certain kinds of, and they're usually pollutants or toxins, should be reduced to what's called a safe level. And a safe level is not an absolutely safe level. It's a kind of what we think of as the irreducibly minimum we can get, given that life is inherently risky because activity just does produce certain amounts of harm or injury. And there's a tendency in this literature, perhaps not entirely adequately, to focus on 1 in a million risk of something as a kind of magic number. But the idea is that kind of risk is a risk that you would ordinarily disregard because there's so many things that can kill you. That really counts as safe. And the feasibility norm is a norm that's found primarily in federal workplace safety regulation. It's the dominant norm for the Occupational Safety and Health Administration. And the feasibility norm says reduce a risk as far as possible, consistent with tolerating the long run flourishing of the activity. So it is a retreat from the safety norm. It applies when you think you have some kind of activity. And the activities, interestingly, that are focused on in the leading early cases articulating it are now things we probably might like to do without, because petroleum is one of them, refining petroleum. But the idea in these cases is you can't really imagine the society we live in functioning without petroleum. But you also cannot make the refinement of petroleum safe to the safety level except by shutting down the activity or crippling. That's not acceptable, therefore you go to the feasibility standard. Now, these standards have been universally criticized by law and econ scholars, and it can seem in the American risk regulation literature that there is no opposition to criticism of them. Cass Sunstein has written 6 of the same books criticizing these standards. And the argument is just the straightforward economic argument. It's irrational. And the reason it's irrational is that on an economic view, rationality is defined by maximizing value as economists conceive it. You should think of tort law and risk regulation as price systems. You should think of everything as pluses and minuses on the same scale of value. Everything is fungible with everything else at some ratio of exchange. Just figure out how much you should put in the way of a price and then trade it off. But never should you adjust the trade-off point not to be the efficient point. It's just irrational. You're preferring less value to more value. And so my argument is, this is certainly true in its own terms, but the terms are eminently contestable, I would say mistaken. Since it's only me and 1,000 economists, I'll say eminently contestable. The reason is that the other way to think about this is not to think about it in terms of economics, which is a sense of descendant of utilitarianism, but to think of it in terms that I would identify broadly with liberal political theory, particularly Rawls or Scanlon, and to think of it here as values as incommensurable and plural, and as the role of the state is trying to establish certain kinds of basic conditions for persons to pursue their own lives as they see fit. And one of those conditions, a kind of Rawlsian primary good, not on his list of primary goods, is safety or security. That's something that everyone needs if they're to lead a reasonable, decent, independent life of a normal length. And that stands in an asymmetric relation to ordinary costs. That is, harm and benefit in this framework are asymmetrical, not symmetrical. I think that's actually our ordinary moral intuition, is that harm and benefit are asymmetrical. And the reason for this is that physical integrity has the quality of being very broadly valuable. You need physical integrity for almost all normal human life plans, whereas benefits tend to be much more relative to particular life plans. They're sort of even extraordinary wealth is good for some people and sometimes bad for many of us in many circumstances. It's true for all kinds of extraordinary talents, whether it's mathematical talent, athletic talent, or anything else. These things tend to be much more particular to life plans. I think you can actually see that in law in two basic structural features. Think of the American legal system. The law of torts is robust. The law of autonomous restitution is very constricted. The law of autonomous restitution is restitution not as a remedy, but as a right. And that requires a circumstance where you impose a benefit on somebody, but where we can say, that's not an imposition upon them that they should have been at liberty to choose. In fact, much imposition of benefits looks like harms because you're taking control of somebody else's will and telling them, yes, the music I'm playing outside your window is wonderful music. You ought to be paying me for it. Circumstances where we regard benefits as unambiguously beneficial and their imposition on someone elicits an obligation to pay for it are very few. And it's because of this asymmetry between harm and benefit and the roles they play in our lives. It's also the case that the American Constitution contains a takings clause requiring the government to pay just compensation when it takes property, but it doesn't contain a benefits clause. And of course, many things that the government does is both harm and benefit. Just a simple example, like a freeway. If you build a freeway, you take property from people through eminent domain to build a freeway, but there are an enormous number of people who benefit because suddenly they have property near the freeway, and we don't attempt to recoup those benefits. So there's this deep asymmetry, and it's not an irrational asymmetry. It's rooted in a different understanding of morality as a matter of the relations among persons, different understanding of the responsibility of the state as establishing conditions for persons to pursue their own lives. And within that, the harm and benefit are asymmetrical, and it is the logic of their asymmetry that's tracked by, if you line up three different standards in American law. The safety standard as the most stringent, then the feasibility standard is next, and cost-benefit analysis is third. There's even a place for cost-benefit analysis, and it is illustrated by Vincent, which is when you have purely fungible property and its value is simply its commercial value, then the proper level of precaution with respect to that precaution is efficient precaution, because efficient precaution captures the value correctly, and any question of fairness that you have can be dealt with after the fact. If it's unfair to transfer the loss from the owner of the dock to the owner of the ship, well, that fairness can be rectified by the payment of reparation after the fact. That kind of fairness can't be done ex post when we're dealing with irreparable injury. And then if you take those two other standards, what you would think is, in a first best world, the economist equivalent in my world of the efficiency standard would be the safety norm. That is, the ideal social world is a world in which everyone can think they can live a normal lifespan, they won't suffer irreparable injury or premature death at the hands of some wrongful agency or toxic substance or the other things that tort law addresses. And then the feasibility standard is the retreat that we make when an activity is so valuable that we can't give it up. But it's also the nature of the activity that we cannot have it attain the safety. So that's that. And I'm thinking, is that the same asymmetry that underlies people's aversion to autonomous vehicles? And gotten no further than posing the question. I'm shocked you looked at start.
Hey, I didn't put. I waited to put my hand, which is progress. Incredible conversation. So thank you so much for this, Greg. We have had a few conversations about some of these issues.
I must be getting less triggering because you didn't put your hand up. But go ahead.
So I have what I believe to be a slightly different question as well. version of the old question. We begin with a slightly different question, which is that in Commonwealth legal systems, the UK, Canada, Australia, New Zealand, Singapore, the standard of care in negligence requires that an act is negligent if it creates more than an infinitesimal risk, which Lord Reed puts in terms of something happening so many times in thousands of years,
Right.
or once in so many thousands. So one question is whether that wouldn't just solve the problem. If you had the right standard of negligence, then of course you would have the level of safety for everyone against these irreparable injuries. Now, of course, it is true that it would still happen in so many thousands of years. But of course, that's going to happen with your safety standard too. Your safety standard is not going to reduce irreparable harm to zero. It's going to reduce irreparable. So that's the first part of it. But the reason these are not two questions, it's a two-part question, because if you put it that way, then you're focused on the case in which the creator of the risk must keep the risk within a manageable level. Now, when you go to your discussion of safety and feasibility, it seems to me that although you talk about the asymmetry between harm and benefit, that's not actually the asymmetry to which you are attending. I actually think that you are attending to the asymmetry between the creation of a risk and the amelioration of the risk. Here's why. If you're just concerned about the value of safety, and again, obviously I'm entirely with you against the economists on this, then it seems to me that you would not have the feature that either the law of tort has or that the safety standard has, which is it puts the burden only on the creator of the risk. It doesn't put the burden on third parties. But if life is so valuable and incommensurable, there's a question if you're putting it in the vocabulary of value and the protection of the thing that is irreplaceable. Again, I agree, I think it's irreplaceable. Why there isn't the same kind of duty to protect people against risks posed by others or posed by nature. Because if we're talking about what people would agree to behind a Rawlsian veil of ignorance or a Stanwellian contractual co-deliberation, it seems that what they would want, they don't care if they're interested in the conditions of their own agency. They don't care about being protected from each other. They just care about being protected. But that means they would willingly, just as they would forego the advantage of imposing risks, it seems they would also willingly accept the burden of protecting people from risks occurring from nature. But that's not just not the way that the law of tort normally operates, but that doesn't seem to be the way in which the safety standard as you described operates. So I want to know why we put the burden on the risk creator if we're going to explain it in terms of the impossibility of remedying these harms, given that the cost of preventing these harms could be managed by others.
Right, so I actually think it's more than two questions, but it's all parsed them a bit differently. On the beginning with the negligence law, I find English cases somewhat elusive, and I think that's partly a feature of even in England that common law adjudication doesn't articulate standards the way a regulatory process will. But when you look at the United States and you do have jury adjudication, too little of it, vanishing trial, et cetera, but nonetheless, in its impact on law articulation, you're looking at a black box. So my intuition is that juries do think the way English law thinks, and that English law thinks the way that the safety and feasibility norms think. And that you could see that as the common law expression of the safety and feasibility norms. I think there's less there to work with if you're trying to explain norms, because the law articulation process is develops law less. But in that thing, the fundamental difference is you still face in a common law tort system, a private law tort system, that reparation is the remedy. And when you get irreparable injury, you still face the wrongful death problem. The common law correctly concluded in terms of its own logic, there is no recovery. So the question is, how do you think about the significance of that? There are at least two different ways you can think about that. You can think of it either in the economist terms as no incentive to perform, or you can think of it, I think, sort of in more social contract terms as you have an assurance problem, because it is the prospect of responsibility for the harm that is the assurance that somebody has that other people will honor their obligations, even though self-interest might tempt them not to. So I think you still, even if you accept that it would be best, and juries tend to think this way, so maybe they do, to interpret the negligence norm as a safety or feasibility norm, depending on what you're confronting. I think you would still think that the common law suffers from this problem of being tied to reparation as its default remedy, and reparation being inadequate the more severe, the more irreparable the injury is. So I think you would still see the regulatory alternative as kind of necessary to complete tort law. Okay, I think there are a lot of things raised by the second question, and one thing that's raised is, like, I give an example here, which I'm a little ambivalent about, but I keep sticking with it. And the example I give is rescues, and rescues drove the statistical, the early, and still in some ways the most brilliant, as the literature got routinized, literature in economics on the value of life. Showing, for example, a life you may save may be your own, found the whole literature. And rescues were the quintessentially irrational human activity, because, you know, when Thai kids are trapped in a cave, or miners are trapped deep down in a mine, we sure don't do cost-benefit analysis. And the extreme version of this, I think, is actually the rescues that the military will undertake in war. It will go after corpses. And they actually follow, I think, a feasibility norm, because feasibility is really possibility. If it's possible to reduce the risk, you should. It's not possible because you destroy the activity, you don't. Well, it's still a feasibility possibility norm. It becomes ultimately foolish to attempt to rescue even a corpse if there's no chance of doing it. So it's the chance of doing it that is the success. So it can govern what we would call in tort law, correctly, we call it morality, I think we call it everywhere, an affirmative duty. Okay, you can have an affirmative duty that's governed by the feasibility standard. And the reasons for that have to go, and here's where the example I think is pulls me away from certain central themes in tort law. There are very particular values when you think of the military. You start thinking of Durkheim and the value of solidarity, and how it is the affirmation that everything the military is about would be destroyed if everybody in the military acted on cost benefit understandings. That's not a place where the morality of the marketplace could enable the institution to flourish. And it's very specialized. We don't think of the workplace as, notwithstanding Marx didn't take in this respect, we don't think of the workplace as a natural habitat of solidarity. So justification here has to be more about the value of life. Irreparability, it doesn't have that particular value component. But a norm like feasibility can apply to negative duty. It can apply to affirmative duty. It could apply to reducing natural risks. Okay. Now, on the second one, on what I think of as the third part of your question, or part of your second question that I answered here didn't answer. I'm not sure between two different things. I think we're thinking about what the domain of morality is differently. For example, some things we should protect ourselves against, but they don't trigger resentment, right? So think of, Rousseau. Men resent injustice, but They don't resent misfortune, they regret misfortune. So earthquakes are misfortune, natural forces are misfortune, somebody else imposing a risk on you that they could have avoided had they taken more precaution, and they should have, that's an injustice. Okay. So I think that we're talking about a certain domain. And we would care behind the veil of ignorance about institutions that goes beyond Rawls, because Rawls is concerned with justice, but you can certainly do a veil of ignorance where you start asking, how should we approach natural disasters as something that we need to address? But they would be different from a question of justice, because the question of justice would just arise. And so if we're mitigating natural disasters, who should be responsible for mitigating them, and how should we share responsibility for doing so? It wouldn't be what do we owe to each other in the core way it is with justice. So that's how I tend to think about the domain. But the other thing that I think that goes on is, I think you and I have very different views of how much affirmative duty there is in the law of torts. I think, for example, that terror stop is just straight affirmative duty. It isn't a borderline case of negative duty. I don't know if terror stop's known on North American world, but terror stop is a famous California case where a student at the University of California at Berkeley went to see a therapist, told the therapist that he was going to kill his ex-girlfriend who'd gone away for a semester in South America, and that he was going to kill her when she came back. Therapist believed boyfriend. Therapist told, I think, actually, the security at Berkeley. They didn't do anything. Girlfriend gets back, gets killed by boyfriend. And the California Supreme Court says the therapist had an affirmative duty to warn. I don't think you can make that at all into negative duty. I think it's pure affirmative duty. And I think the law just is willing and should be willing. This is, I think, where we have our disagreement. The other one about constructing the domain of morality is not so clear to me how we disagree. But I think the law should be willing to impose easy duties to rescue. And I don't find that troubling. And I think that may go to the difference between an interest view of rights and a view that negligence is grounded on our interest in physical integrity as opposed to grounded on powers of choice over other people and so on. So that's why I think your second question splits into multiple questions.
Thank you. Thank you, Greg, for your presentation. I have two questions. Initially, I had one, but something that you mentioned at the very beginning made me think of another. So I have to start with the second. And I wonder, because we have enough evidence and I think enough agreement that tort law is very bad at the system of reparation. And so what I tend to think is, well, they must be doing something else, right? It's so bad at doing that. And so why we are still assuming that starting point again and again and again in tort theory in general. And so I'm trying to question that. And you mentioned, yes, there is something about expert theories or something about damages that could bring some partial answers to this problem. But what I don't see is, or I see that this is an underdeveloped thinking. And I want to hear your thoughts on that, because I don't see that, I see a lot of, that expressive theories we can just give it a and continue. And I'm interested in exploring more about that. And I'm interested in exploring more about what is really the meaning of money, whether there is something that also beauty damages depends whether you have a determinant perspective or other perspectives. On that, we can talk about that later. But this is one aspect I want to push. Are we not assuming that sticking so much with the assumption of reparation, and whether there is much more to explore there? And then the second question is about the limitation to take the relationship towards regulation. I think it's very interesting and also challenging, especially if you consider the American landscape, right? Because you have a regulator that is dominated by the cost-justified precaution idea, and C itself, the role of the regulator is dominantly that one. And so what I was wondering is whether it would be helpful to get in that conversation, which is the regulator you are advocating for. It's a regulator that is much more sophisticated, that has to get into a nuanced judgment of risk assessment. It's a different kind of regulator than the one you actually have in that context. And trying to push the thinking of autonomous vehicles that you are trying to connect. I was wondering whether it won't be useful to look at the AI Liability Act at the European regulator. Because what they are trying to do, I think, fits a little bit with the distinction in saying, well, when we prohibit certain activities, we are following the safety standard in this risk-based approach. There are other activities that we are not that sure, and maybe it's a little different standard.
Right.
And at the same time, this is dynamic because it changes. Because of course, in the context of new technologies, we don't know there are activities that so far they are not high risk, but they could become high risk. And so there is a role of the regulator that is, I think, much more in line, if I understand correctly, for what you are thinking. It should be the role of this direct regulation that rescuing thoughts in this idea of preventive harm. So I want to hear a little more about that and whether these ideas are getting or not. Thank you.
I think that second question, which I'm starting to puzzle about, because I think I probably should start thinking about both AI and autonomous vehicles. One of the things you're pointing to is uncertainty, right? And in the feasibility standards and safety standards in environmental and health and safety regulation, the problem isn't uncertainty in the sense that we don't even know objective probabilities. They go to lots of trouble and it's very time consuming, and perhaps that's one of the problems because administrative processes can grind very slowly to assess the risks in pretty refined ways and to gather lots and lots of data. But one of the things that we are facing with artificial intelligence and autonomous vehicles is not being sure from one moment to the next what set of risks we're assessing, okay? And then we're also facing this somewhat, this may be the wrong way to frame it, but it tends to get framed as much for rhetorical reasons because there are very powerful interests that are pushing things like autonomous vehicles as, but just a question of substituting a safer technology for a less safe technology. And when you frame it that way, you're framing a classic sort of razor's edge efficiency standard. If you've got one level of safety and you can improve it by any amount by changing a technology, well, of course you would, right? And that isn't our view. The lay view, I think, and all of our views actually of autonomous vehicles is that's spooky at a certain level because that's a machine, it's not a moral agent. Does it recognize me as a cyclist, or does it think I'm a tumbleweed and no problem running me over because tumbleweeds aren't important things in its programming? And so we want a much higher level of safety. And I don't know if it's because, is it because of uncertainty? I have the feeling it's because we can't count artificial technologies, artificial intelligence or RAV as moral agents, and therefore the responsibility has to pass through to somebody else. But in practice, in the legal system, we're trying to wedge them into categories where the only things in those categories before were actual persons who are moral agents. Like whether, while we think about it in academia, autonomous vehicles are showing up on the streets of Los Angeles, and they're going to be treated in terms of a traffic code that's designed for human drivers, even though nobody's going to think that when either a Tesla or a Waymo AV violates a traffic regulation, it's accountable in the sense that a person is, and we're going to ask if it's drunk and whether it went to, we're going to think driver's ed school, and we're going to think, you know, lapse of responsibility and so on. It's nonetheless going to be wedged in there, and it's very puzzling to know how we should model that. Coming back to the first one on expressive damages, I think why do I come across as a bit ambivalent about them? It's because you can develop expressive damages with great subtlety, but the problem that people are facing is they're not getting adequate protection against getting killed. And after the fact, articulating the expressive significance of damages with great subtlety. It has its appeal because it's very interesting and because you can say very refined things about value, but it can seem a little bit like in the cases that most bother me, which is only one kind of case, it feels a little bit like missing the point, okay? But that's a particular kind of case. For example, in thinking about your paper, I started thinking about Scott Dershowitz's favorite case, whose name I always forget, but it's the case where it was somebody who's rich, powerful, arrogant, at best arrogant, probably much worse than arrogant, spits in the face of somebody else when the other person like wins a lawsuit against him or something, and doesn't just spit in his face. It's like, you know, cultivates the spit before spit it in the most offensive way possible. And that's a case that Scott thinks of as, maybe he thinks of it as expressive damages, maybe he thinks of it as the expressive role of process or something like that. Maybe you could think of it as the exercise of power. That is, this guy exerted raw power over me, and my calling the court for their assistance and making him pay a lot is exerting raw power over him. I think that's a very, very interesting thing, and it doesn't, what I'm thinking about doesn't respond to that. And I also think there are clearly things going on in ordinary tort law that are not about reparation. They're about just that the process element is calling somebody to account. So the process of bringing someone to court and offering your account of what happened and holding them to account for having wrongly harmed you, that itself has got to be part of the value of tort law. And it has to be the case that damages in some circumstances not only contain an element to respond to that, but are the best we can do with it, because what we're responding to isn't the irreparability of the injury, it's the kind of disregard that the defendant showed for the plaintiff, or it's the kind of harm that the plaintiff suffered that somebody shouldn't have to suffer, and we've got to make a kind of eye for an eye, tooth for a tooth suffering on the part of the defendant. So in all those places, my kind of uncharitableness only applies to, it's not really the point when people get killed. And man, of course, I'm inadvertently killed. I hope my children get wrongful death damages and build a monument to me and everything, but I prefer it that did not happen.
Thank you, Greg. I'm just trying to find my old notes from our last meeting that in those days, I have a comment that I didn't use in our last discussion about the city.
I have that problem too. I lose my own comments.
But
I'm still
trying to reconstruct the idea. I don't fully understand how you analyze the asymmetry between costs and benefits when you criticize the way of analyzing negligence and liability in general, because as I see it, on one side of the equation, you have costs. Costs sometimes have monetary value, sometimes do not.
Right.
Paying more attention or not doing something that has non-economic value. So it's measured in terms of liberty. You lose in order to what? To protect what is in the other side of the equation, which is a reduced risk of physical harm. Right. So the benefit in the cost-benefit analysis is protecting your physical integrity. Right. And the cost is sometimes losing some freedom.
Yeah.
And I don't see now how this is problematic for one. It seems quite sensible to think, okay, at what cost can I reduce 1% of the probability of you suffering some physical harm, which is the cost to me. It doesn't sound like an absurd question. It's quite.
Yeah, no, I think.
This is the first thing I'm going to have.
Okay, do you want me to go with this one or not? Maybe let me make sure I'm tracking it. It turns out every now and then I get some economists who are sympathetic to me, and we're saying driven much more crazy by Arthur or Ernie than they are by me. And I think it's because You can count that as a point of pride. You can regard that as vindication. I regard that as some alarm. You'd always like to convince people, but you're not sure you've convinced people, as opposed to, as this was thinking, oh, I'm not quite saying that. But so what the economists can think is it's just a matter of valuing the interests, right? I think, and that whether you call it liberty interests and security interests, or you call it costs and benefits, it's just a matter of how you value it, okay? But I think there's something more going on in cost benefit analysis, and it is that it's the idea of universal fungibility, right? And I think I have an interest theory of rights, but I have a theory that some interests are more important than other interests. And the problem is how to find terms of trade-off that respect the superior importance of some interests relative to others, and that is what the safety and feasibility norms are doing. So they're articulating different terms of trade-offs. You're not just deciding how valuable the two interests at stake are in terms of just put more of a thumb on the scale on the side of security and add more dollars to it, which is why I think the economists think I'm making a kind of sense that, say, Arthur and Ernie aren't, and that I'm not as far from them as I think I am. And I think the answer is you could get something that would look like what I like by jiggering cost benefit analysis. But I think what you'd be doing is trying to track what you get if you think about it the way that I think the law thinks about it. And the law isn't really thinking about it in the way that cost benefit analysis is thinking about it. So you would generate a cost benefit analysis that can track it. But it isn't it would be sort of like a sociopath ball. That's too harsh.
I agree with the criticism if you take money as an end. But I don't think any scholar now thinks of money as an end. When you are investing a lot of money to save one life, this is money that you cannot use to save many other people. There is a case in Brazil which was famous because the Supreme Court allowed for experimental treatment to cover the site one person who was the claimant. But the treatment was so expensive that according to the laws, it was just one town had to pay for the treatment. That town didn't have now enough money to give some medicines or regular means to treatment for in public hospitals. So money is important because of what we do. It's not money, it's what is behind money, what we can do with that money, and it doesn't make sense.
Right. So no, I do have a couple of comments on that. One is, I think in thinking about the difference there, we have to start sorting things out in a somewhat different way. A standard economic way of thinking about something like a railroad accident. A railroad accident happens because somebody doesn't throw a switch, okay? And an economist gets in there with cost-benefit analysis and starts asking, kind of from the point of view of God, so how much should we be valuing all of the relevant interests here? And does it make sense to spend more preventing this one railroad accident when we could be preventing, malaria among children in the third world or whatever? And it's just entirely not the question of responsibility that's framed by the issue at hand, all right? And there's a characteristic of economics to move. I mean, one of the things that you're thinking in the statistical logic literature is to move to the idea that everything was being decided from the point of view of God. You got to figure out what is that underlying idea, what drives them to think that way, and then to articulate why it is that questions of interpersonal responsibility have a very different structure, okay? And there, I wouldn't be close enough to Arthur for Arthur to make him happy, but I'd become closer to Arthur. And then the other thing going on is there are some things in economics that it's kind of hard to figure out what the real structure is, because a simple version of economics would be old-fashioned cardinal utility, okay? It would just say, what we want is to get at cardinal utility and everything has a cardinal utility, and we would try to figure out some index for that, and if money's not perfect, we try to find some other index, okay? But modern economics rejects cardinal utility and goes for ordinal utility, so that it just focuses on everything as how one person would rank various goods. But then when it tries to get interpersonal, it turns around and says, well, what would people be willing to pay? And when you turn around and say, what would people be willing to pay? I think you're kind of bringing cardinal utility in through the back door. And if you've got cardinal utility, then what you really have is a theory of value that is homogeneous, in which there are not qualitative differences in value. And I really do have a different view of value, and everybody, not just Toronto Kantians, but everybody on the liberal side of the divide has a very different view of value, and so do Aristotelians. So, and I think economists really are sneaking a cardinal utility view of value into their cost-benefit analysis when they make willingness to pay the critical criterion. Is that on? Yeah.
I don't know if you have a question. I got the second question. And the second is again about the Vincent.
Oh, yeah, we talked about that in a different country a couple months ago. That's not David thinking about.
I guess now just one more question. For you, is this case of strict liability?
Well, yeah, it is because, but I would also say eminent domain is because it.
No, but then you keep saying that it's a case of efficient precaution.
Well, the correct level of,
This strict liability.
oh yes, the correct level of precaution to take against the harm. So Vincent, one probably has to, I think I'd have to write another paper on Vincent. I think I've regarded it rightly as he is obsessed with Vincent, but I have to write another paper. But you can look at Vincent through several different lenses, right? So one lens to look at Vincent is, it's a mandated rest piece, okay? Because the ship owner gets to use the dock owner's property for an easy rest, okay? Another view of Vincent insists it's a trespass case, okay? And my view says, well, I think it's a privileged case where I'm not really resisting the entry case, but I am resisting the trespass one because I think the right to exclude part of your property right has been extinguished. But I think Vincent also illustrates the fact that there's nothing to criticize in the conduct of the ship owner. It's one of the traditions on Vincent. Richard of Epstein is the principal proponent of this, says, well, think about this as a case of a single owner, which is an idea that has deep roots in American negligence law. Very early formulations of negligence law in the 19th century say, the way we should think about the level of care owed is in terms of if a single actor owned both the imposition of the risk and the harm from the risk, what would they do, okay? And Epstein says, well, in a single owner case, you take exactly the precaution that the ship owner took, which is damage the dock, don't try to save the dock, but you'd also have to bear the cost of it, okay? And that's Epstein's way of explaining why it should turn out the way it should turn out, okay? In my terms, it illustrates strict liability because I think the most common version of form of strict liability in American law is one where it is not wrong to inflict the injury, but it is wrong not to make reparation for the harm you've done because it's wrong to make the victim bear the loss. So the way you would put it in Vincent is it's wrong to transfer. This is actually Holmes's term, I think, when typical Holmes is 2 sentences on Vincent, but wrong to transfer the loss to the dock owner. Okay? Then back to our earlier conversation, there's no residual reasons because once you pay reparation, this isn't Sophie's choice. This isn't the stuff that was John Gardner about, tragically, you're drowning and I should be able to rescue you, but I can't rescue you. And so even though I couldn't possibly have done it, I've still got it.
But still is the case that the ship owner did not take any precautions. He claimed that took deficient precautions that were zero.
Yeah, no, no,
It's not precaution. So, and the single owner case also is very problematic. That it's the literature about.
oh, yeah, the single owner,
Single owner case is it's not the standard of here we say alterity, like being in a relationship, knowing that there are others, it's not only about you.
well, no, I criticize all the economics for collapsing, so I don't own Richard's analysis, but it is a metaphor. It gets one piece of negligence, I think, which is under negligence in a very basic way, it does require you to treat the victim interests equally with your own, right? You can't be a complete egoist under negligence law. You've got to be impartial between your interest and the interest of the other person. You also don't have to be an altruist. The single owner gets that, but it's not an adequate book. Chapter 4 of my book, attacking that, and because it's a dominant metaphor for the economic analysis, and it destroys the problem of interpersonal justice that's at the heart of it. So I don't generally favor it, but I think it makes it illustrates an aspect of Vincent. I mean, one of the things that makes Vincent, one of the articles of Vincent that approaches it from a rescue point of view has a little footnote saying, "Here's my RA, look it up. It's been tried 12 times in cases, but 300 and something times in law review articles." Okay, and one reason is there's a lot of different prisms that you can look at Vincent through, and figuring out how do you put all the prisms together is pretty difficult.
Thank you, Professor Keating. I have some questions for you. The first one is about what do you think of if we as citizens or persons, we have a legal entitlement to force the implementation of these standards that you talk about.
Say that again. If we have a
legal entitlement, an action,
okay.
legal action to force the implementation of the standards. I say this because we in Colombia, we have this insane case that asbestos only was banned until 2019.
Wow.
While in Europe, the consequences of asbestos in Europe was banned in the decade of the 70s. But we didn't have any legal action to force to the Congress to regulate this, to apply any of these standards. So do you think that we have this kind of legal actions? And if your answer is yes, then what kind of justice are we implementing in these cases?
So if we don't, so I think the question is, if we don't have a statutory scheme, what kind of justice are we doing? So I guess in the American system, what you do is you default to tort law. It is the default. It isn't. There are problems with this as anything more than a metaphor for these purposes, but it's the default risk regulation system in the United States, and that means if it hasn't been displaced, you go to tort law. And I suppose the right thing to think in tort law is asbestos. I guess asbestos falls into a feasibility standard, although when we figured out how dangerous it was, we just banned it. Okay, the question is really whether, in the American history of asbestos, the disaster happens primarily as a result of World War II with massive shipbuilding for the war, and asbestos being a insulating material of unparalleled effectiveness, and shipyards being snowing asbestos in the course of constructing ships. And if you think that the construction of those ships in time of war was urgent in a way that is very pressing, and that there's really no substitute for asbestos, then I think the correct standard to control it is a common law feasibility standard. The history of asbestos as it unfolded in American courts was complex, partly because there was this huge time lag because of the latency period for the development first of as does totus and then mesothelioma, but also because to the extent that courts were able to figure out what happened with asbestos, it appears that the companies that Johns Manville in particular did some research early in the development of asbestos. The research was turning up information they'd rather not know, and they stopped. And so that presented a very difficult negligence question, which was, were you negligent because you failed to undertake reasonable research, facing back now decades, and should we hold you liable for that as a matter of negligence? And courts cashed out solutions to asbestos in terms of failure to warn, and let's not worry about the fact that the risk was unknown. You didn't warn about it. That had the administrative virtue of getting around and ending these endless inquiries into what was known and what should have been known 40 years ago. I don't know if that responds to your question or not.
Okay, and the kind of justice that you see in claiming prevention of harms.
So I think it is an interpersonal justice, but I think the communities of risk involved vary in sort of concentric circles. You can think of some torts cases as involving only two parties. All right, I don't think that it helps to think of, say, even product accidents. That is because it's everybody who's exposed to the risks of products is the community that has the risk imposed upon them. And I think that's a form of interpersonal justice. I would take interpersonal justice very far. I would take interpersonal justice all the way to the New Zealand accidents. Say that regards the relevant community of risk as society at large. We're all in this together. It's an old-fashioned, but in some ways very much in the spirit of walls or town view of what we owe to each other, but very, very different from the particular community of risk that you might see in interpersonal bipolar negligence lawsuit. And if you think of the product liability in the intermediate zone between those, I think some of the questions of punitive damages is wrestling with have dimensions that are affected by the nature of the large scale risk imposed by even the sale of an ordinary product. And I would think of asbestos as involving that kind of large scale interpersonal risk imposition, not just a one-off idiosyncratic individual to person one.
Thank you, Professor.